Good evening. My name is Skip Walther. I'm an attorney at 700 Cherry here in Columbia. And I'm here tonight on behalf of the Columbia Apartment Association. And while we share we share with you the notion of supporting good enforcement efforts with respect to the over-occupancy problem, I am here tonight to encourage you to oppose the proposed ordinance that would require every landlord to create, maintain, and exhibit upon request a zoning occupancy disclosure form and all tenant information. Now, here are the facts as I understand them. There are approximately 25,000 units in the city of Columbia. This ordinance applies to every single one of those 25,000 units. As Lee just told you, in calendar year 2012, there were 46 reported violations, 46 rather complaints with respect to over-occupancy. Of the 46 complaints, 26, after investigation, were determined not to be violations. We're down to 20 in calendar year 2012. Of those 20, as Lee reported to you, 6 of those 20 voluntarily complied without going to court. That leaves 14 complaints in calendar year 2012 that either are violations or we're awaiting some kind of determination with respect to those. Now, 14 violations in calendar year 2012 out of 25,000 units, that number is minuscule relative to 25,000. Now, regardless of whether we're debating the 26 cases after investigation that were determined not to be violations or the others still pending, those numbers do not justify more regulation on the rental businesses in Columbia. We don't have an over-occupancy problem. We may have an issue with respect to getting them through court, the ones that are there, but this ordinance isn't going to address that issue. In fact, I'm not sure how this ordinance affects over-occupancy in any way, shape, or form. Most leases are signed. There are some oral leases, but most leases are signed. And if a landlord is going to allow more than 3 people or 4 people, as the case may be, to sign a lease, what's to keep him from finagling with the form? I mean, I don't understand how this form is going to solve an over-occupancy problem, and I certainly don't understand how a city with 25,000 units and 46 violations in 1 year has a problem in the first place. Now, the staff report talks about the fiscal impact of the City of Columbia, and the staff report correctly notes that there isn't a fiscal impact for city government. But what the staff report doesn't tell you is what the fiscal impact is going to be for those landlords who have to comply with this lease or with this ordinance. Now, the ordinance, as I read it, is immediately effective. If it's passed tonight, it's effective the minute you vote on it. 25,000 units, don't know how many tenants are in town. I'm going to assume an average of 2 per unit. That's 50,000 tenants in the city of Columbia. This year, 50,000 people are going to have to either sign this form or enter into revised leases. Now, the professional landlords who I represent are very conservative and very cautious. Many of them use attorneys. And if they're going to have this language inserted into their lease, they're going to consult with an attorney before they do so. I'm an attorney who practices with real estate law, and I can tell you that there's no way I'm going to do this work for a tenant for a landlord without reading the lease in its entirety and providing the benefit of my education with respect to those leases. That's going to be a minimum, and I mean a bare minimum, of $200. If and I think there are about 1,500 landlords in this town, if every one of the 1,500 landlords goes to an attorney and spends $200 on getting this work done, well, 1,500 times 200 is $300,000. Now, additionally, all 25 leases, all 25,000 leases are either going to need to be amended or a disclosure form signed. That, assuming an average, again, of 2 tenants per unit, that's 50,000 signatures. The time and expense it's going to take a landlord, 1,500 landlords, to meet with 50,000 people to get new signatures is going to be staggering. How much time value would you place on what it's going to take those 1,500 people to meet with and extract those 50,000 signatures in 2013? I'd estimate hundreds of thousands of dollars. Now, let me go back to, again, the problem. we've got 14 violations and 25,000 units. Is that a problem that justifies the private landlord businesses in Columbia of spending hundreds of thousands of dollars to comply with this ordinance? I would say that this ordinance is obviously unnecessary. Now, of equal concern is the idea that our police, as this ordinance is written, will supposedly have the right to an unlimited search of all lease and tenant information just by announcing they're investigating a code violation. And a code violation, as this ordinance is drafted, could be a fire code, a building code violation, a sidewalk violation, a sign ordinance violation. And with a violation, if an officer is investigating according to this ordinance, he can get all leases, all disclosure forms, and all tenant information. Now, tenant information isn't something that a landlord is legally obligated to obtain, but the good ones do. And this ordinance requires landlords to supply that tenant information. It could be Social Security numbers, it could be employment background information, it could be family background information, educational background information. All this information is tenant information, has nothing to do with an ordinance violation or a code violation, and yet this ordinance gives the police the right to a search of that information without a warrant. I don't believe that is the type of law that we should be passing in this city. I urge you to oppose this ordinance and its overreaching and probably unconstitutional regulation of retail businesses. Thank you.
Thank you, Mr. Walther.